Hi, Tony DeWitt here, Missouri Appellate attorney and a guy who likes to make the law make sense on YouTube. Today we're going to try to make sense of the 303 Creatives case that was recently handed down by the Supreme Court. So stick around. Let's discuss this. .303 Creatives is a case involving a young lady who wants to be a web designer and who wants to provide web services for people who want to get married. She wants to provide wedding websites, but she doesn't want to speak things that are not biblically true. And so she petitioned for an injunction against the Colorado Anti-Discrimination Act. Now, before I go too much further, I want to make sure everybody understands I do not hold any discriminatory views toward people who are lesbian or gay. I think that, whatever you do in your bedroom at night, whoever you live with, whoever you love, whoever you sleep with, that's your business. If you come to me as an attorney and you say, I need representation because somebody, hit me in a car, or because I want to get my contract enforced against, Mr. Smith over there, I'm not gonna ask you, well, I'd love to help you, but it looks to me like you're gay. I'm not going to do that because that is odious. That is as odious as discriminating against someone on the basis of their race, their creed, their color, their national origin. All of those things are not something we should engage in a free and open society. People have a right to be who they are. People take a very stern religious view of this, but it isn't up to them to make a determination about how people ought to behave. God could very easily have created us all so that we obeyed immediately. He could have created robots, but he didn't. He gave us free will. And because we have free will, we need to respect when other people engage in acts of free will, even though they're not the same acts that we would engage in. So with that little bit of an opener, I want to start out by going back about 5 years to the Masterpiece Cakeshop case. The Masterpiece Cakeshop involved a cake baker who did not want to put expressive messages on cakes or bake cakes for gay weddings. And he was sued by Colorado. It went up to the United States Supreme Court, and the findings against him were reversed, and here's what the court said about that. Whatever the confluence of speech and free exercise principles might be in some cases, the Colorado Civil Rights Commission consideration of this case was inconsistent with the state's obligation of religious neutrality. The reason and motive for the baker's refusal were based on his sincere religious beliefs and convictions. Still, the delicate question of when the free exercise of his religion must yield to otherwise valid exercise of state power needs to be determined in an adjudication in which religious hostility on the part of the state itself would not be a factor in the balance the state sought to reach. That requirement, however, was not met here. When the Colorado Civil Rights Commission considered this case, it did not do so with the religious neutrality that the Constitution requires. And that's from a case from 2018. Now, with that background, let's take a look at the 303 Creatives case from the Supreme Court. Of Lori Smith, who owns 303 Creative LLC, versus essentially the state of Colorado and its Anti-Discrimination Commission. Lori Smith wants to expand her graphic design business and include services for couples seeking wedding websites. But she worries that because Colorado uses its Anti-Discrimination Act, that they might compel her, in violation of the First Amendment, to create websites celebrating marriages she does not endorse. To clarify her rights, she filed a lawsuit seeking an injunction to prevent the state from forcing her to create websites celebrating marriages that defy her belief that marriage should be reserved to unions between one man and one woman. Now, the Colorado Anti-Discrimination Act prohibits all public accommodations from denying the full and equal enjoyment of its goods and services to any customer based on race, creed, disability, sexual orientation, or other statutorily enumerated traits. The law defines public accommodation broadly to include every public-facing business in the state, and either the state officials or private citizens can bring an action to enforce the law, and a variety of penalties can follow any violation. Before the district court, Ms. Smith and the state stipulated to a certain number of facts. Now, when it says that they stipulated, it means they are considered proved, even though no evidence was admitted in support of them, because they wanted to simplify the record for the court. Ms. Smith is willing to work with all people regardless of classifications such as race, creed, sexual orientation, and gender, and will gladly create custom graphics and websites for clients of any sexual orientation. She will not produce content that contradicts biblical truth, regardless of who orders it. Ms. Smith's belief is that marriage is a union between one man and one woman, and that is a sincerely held conviction. She provides design services that are expressive, and her original customized creations contribute to the overall message her business conveys through the websites it creates. The wedding websites she plans to create will be expressive in nature and will be customized and tailored. Ultimately, the district court held that Ms. Smith was not entitled to the injunction she sought, and the 10th Circuit Court of Appeals affirmed. The court's holding, the First Amendment prohibits Colorado from forcing a website designer to create expressive designs speaking messages with which she disagrees. And then it goes through the free exercise clause, the free speech clause, and it talks about several of the cases in the past that were interesting because they invoked this freedom to think and speak as you like. One of those was Barnett versus West Virginia Board of Education versus Barnett. And basically there, the court held that the statute that required children to face and salute the flag and recite the Pledge of Allegiance invaded the sphere of intellect and spirit, which is the purpose of the First Amendment to reserve from all official control. State authorities had transcended constitutional limitations on their powers. In Hurley versus Irish American Gay, Lesbian, and Bisexual Group of Boston, the court held that Massachusetts' public accommodation statute could not be used to force veterans organizing a parade in Boston to include a group of gay, lesbian, and bisexual individuals because the parade was protected speech and required the veterans to include voices they wished to exclude would impermissibly require them to alter the expressive content of their parade. And then in Boy Scouts versus Dale, they said that allowing a gay scoutmaster in an expressive association would interfere with its choice not to propound the point of view contrary to its beliefs. These cases all illustrate that the First Amendment protects an individual's right to speak his mind, regardless of whether the government considers his speech sensible and well-intentioned or deeply misguided, and likely to cause anguish or incalculable grief. And they cite Snyder versus Phelps. Snyder versus Phelps, for those of you who don't know, was a case involving the Westboro Baptist Church and their protests at the funerals of service members. And they upheld their absolute right to protest at those, even though they did cause anguish and incalculable grief. So applying these principles to the parties' stipulated facts, the court agrees with the 10th Circuit that the wedding websites seek to create qualify as pure speech protected by the First Amendment, and the court agrees with the 10th Circuit that the wedding websites Ms. Smith seeks to create involve her speech, a conclusion supported by the parties' stipulations, including that Ms. Smith intends to produce a final story for each couple using her own words and original artwork. And even though her voice is combined with the couple's, that does not forfeit constitutional protection simply because you're combining with other voices. So, Ms. Smith seeks to engage in protected First Amendment speech. Colorado seeks to compel speech she does not wish to provide. Colorado seeks to compel this speech in order to exercise certain ideas or viewpoints from the public dialogue. Indeed, the 10th Circuit recognized that the coercive elimination of dissenting ideas about marriage constitutes Colorado's very purpose in seeking to apply its law to Ms. Smith. But while the 10th Circuit thought Colorado could compel speech from Ms. Smith, this court's First Amendment precedents teach otherwise. Here, Colorado seeks to put Ms. Smith to a similar choice. If she wishes to speak, she must either speak as the state demands or face sanctions for expressing her own beliefs, sanctions that may include compulsory participation in remedial training, filing periodic compliance reports, and paying monetary fines. That is an impermissible abridgment of the First Amendment's right to speak freely. Under Colorado's logic, the government may compel anyone who speaks for pay on a given topic to accept all commissions on that same topic, no matter the message, if the topic somehow implicates a customer's statutorily protected trade. Taken seriously, that principle would allow the government to force all manner of artists, speechwriters, and others whose services involve speech to speak what they do not believe on pain or penalty. The court's precedents recognize the First Amendment tolerates none of that. What we have here is a good example of the Supreme Court thinking about the next case or the next situation that it might face. Basically what it says is the state is trying to force individuals to speak things they do not wish to speak. So one really good way to analyze whether or not a rule is a good rule or not is to turn it on its head. In other words, let's look at this from the standpoint of a gay web designer. I'm sure there are some really good web designers out there who also happen to be LGBT, right? I understand that that's probably more than likely in almost every state. So let's suppose that the state made a rule or passed a law that said you absolutely have to provide whatever speech that somebody wants in a website. So let's suppose that a straight couple went to this web designer and said, we want to put a website up, but we absolutely require you to put on here that gays and lesbians are freaks of nature and should never, ever be allowed to get married anywhere. And it's an abomination if they do. And so if you wouldn't compel the gay person in that situation to say things that they don't believe in their heart, that are they may not be protected religious beliefs, but certainly their core fundamental beliefs and deeply held, then certainly, at least as far as the free exercise clause goes and the First Amendment protected speech clause goes, you have to allow them not to do that. So I think that's one of the reasons that this is a pretty good opinion at this point. This court has recognized that public accommodations laws vindicate the deprivation of personal dignity that certainly and surely accompanies denials of equal access. And they cite to the Masterpiece Cakeshop case that we talked about. Today, for example, approximately half the states have laws like Colorado's. The court has recognized this as unexceptional in Masterpiece Cakeshop. States may protect gay persons just as they protect other classes of individuals. At the same time, this court has also long recognized that no public accommodations law is immune from the demands of the Constitution. As in those cases, when Colorado's public accommodations law and the Constitution collide, there can be no question which must prevail: the United States Constitution. And they cite Article 6, Section 2, the Supremacy Clause. So that's really the heart of it. Colorado now seeks to acknowledge that the First Amendment does prohibit it from coercing Ms. Smith to create websites expressing any message with which she disagrees. Colorado's theory rests on a belief that this case does not implicate pure speech, but rather the sale of an ordinary commercial product, and that any burden on Mrs. Smith's speech is purely incidental. But the court disagrees with that. The First Amendment's protections belong to all, not just to speakers whose motives the government finds worthy. In this case, Colorado seeks to force an individual to speak in ways that align with its views, but defy her conscience about a matter of major significance. In the past, other states in Barnett, Hurley, and Dale have similarly tested the First Amendment's boundaries by seeking to compel speech they thought vital at the time. But abiding the Constitution's commitment to freedom of speech means all will encounter ideas that are misguided or even hurtful. Consistent with the First Amendment, the nation's answer is tolerance, not coercion. The First Amendment envisions the United States as a rich and complex place where all persons are free to think and speak as they wish, not as the government demands. Colorado cannot deny that promise consistent with the First Amendment. Now, Justice Sotomayor, bless her heart, has written a dissent here, and she tries to make a distinction that the court and these statutes, these public accommodation statutes, don't actually target speech, that what they actually target is conduct, and that as a result, they should stand because they target conduct. But if you were to take that view, you would take the view that the conduct of the people and in the Westboro Baptist Church cases, right, where they were out there creating a scene, holding up signs that were terribly offensive and denigrated the loss of people who lost brave soldiers, sailors, airmen, and Marines in Afghanistan and Iraq. And you would have to look at that as conduct as opposed to freedom of expression. And it is always interesting when someone glosses over one line of authority and emphasizes a different line of authority. Let's take a look at a couple of things from Justice Sotomayor's dissent and analyze it and see what we think. And here is Justice Sotomayor's opinion, her dissent. I'm just going to go through a couple of things here that I think is an example of what happens when someone who has lost a case, whether it's an advocate or, in this case, a judge who is not in the majority, will certainly adjust the facts to suit their message. I believe she's being intellectually dishonest here. She may believe she's being completely honest. I don't know. But it's pretty clear that her view on this is framed by her beliefs, not by the law. In other words, she is attempting to be an activist judge here. Today, for the first time in its history, it grants a business open to the public a constitutional right to refuse to serve members of a protected class. That's incorrect, because the Cakeshop case essentially held the same thing. The court also holds that a company that has a right to post a notice that says no wedding websites will be sold if they're used for gay marriages. Again, that is absolutely not correct, because the stipulations, if you will require, said she was willing to work with gays and lesbians in her business. And the only thing that she objected to was putting messages on the website that contradict a biblical truth. So when she sweeps broadly like this and takes the 50,000-foot view, she is ignoring those stipulations that essentially said she doesn't hold any bias or any discrimination against people who have that sexual orientation. She merely wants to make sure that her religious rights are respected. And she takes note of the fact that there's been a backlash for equality of gender and sexual minorities. And I don't dispute that in some quarters that's true. But she says, the business argues, and a majority of the court agrees, that because the business offers services that are customized and expressive, the free speech clause of the First Amendment shields the business from a generally applicable law that prohibits discrimination in the sale of publicly available goods and services. That is wrong, profoundly wrong. As I will explain, the law in question targets conduct, not speech, for regulation. That is not the case, because it's targeting her expression. She does not wish to put anything in there that violates a biblical truth, which she holds very dear to her heart. And when you say it targets conduct, not speech, you're simply ignoring the fact that when you force somebody to say something that goes against what they believe, that you're not really targeting conduct, you are compelling speech of a certain variety. It's worth noting in the Masterpiece Cakeshop case that Justice Sotomayor joined with Justice Ginsburg in dissenting in that case. She joined Justice Ginsburg's dissent, adopting it as her own dissent. Here, what's interesting is that in this case, Kagan and Justice Jackson both signed on to Sotomayor's dissent, but Kagan was in the majority in the Masterpiece Cakeshop case. She was in a concurrence in that case. So to me, this is, to a certain extent, there are some political overtones here, as there are in almost every one of these cases. And so you have to read the dissent to really get a flavor for what she's saying here. And again, I could take time and go through the entire dissent for you, but it's probably better if you go and read it yourself. You can get all of these opinions through the SCOTUS blog. It's scotusblog.org, I think, or maybe com, I'm not sure. If you type in SCOTUS blog in your browser, it will take you there, and you can find 303 Creatives LLC and download the opinion and read it for yourself. It's an interesting case, and again, I think it's pretty reasonably decided. There is a big difference, I would point out, between the Cakeshop case and this case. In the Cakeshop case, he did not want to bake cakes for gay weddings. And there is a distinction between providing a cake, which is a commercial product, and providing an expressive website with words and speech that is actual speech. Now, maybe putting two men or two women on a cake is expressive also, but that's not the key part of what he's doing. He's baking a cake. So all they did in the Cakeshop case was remand it basically for a religious neutral, or I should say a more neutral evaluation. And for that reason, I think it was well decided. In this case, I think it's well decided because there is a huge creative issue here. And as an attorney and as a writer and as a content creator here, I would not wish to be forced to create speech that I disagreed with. Thank you so much for watching. If you have an opportunity today, do something nice for somebody and have a marvelous day. Catch me down here next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.